grade and 49 years later. My name is Elena Taylor, and I am the Dallas Area Paralegal Association's medical/PI and real estate section chair. I am joined here today by Laura Kehoe and Mr. John Birmingham. We appreciate you taking the time to attend during your lunch hour. You know you can be doing something else. uh, Here are some announcements and some housekeeping information. Our general membership meeting is on September 19th, so be sure to register for it. Also, our Wendy Rogers Mentorship Workshop is this weekend. Please go to our website calendar to get the link to go to the website to register for that. Also, for best practices, can you please put your full name on the screen so that we can confirm who attended this meeting? This acts as our sign-in sheet for Zoom and acts as the checks and balances to help verify attendance. So if you can, please input your full name whenever you log into Zoom. Okay. Today's presentation will be an interactive session, so feel free to post your questions and comments in the chat room, and we will monitor those. Towards the end of the CLE, a passcode will be issued. If you would like to receive a certificate of attendance for this presentation, you will need to send a request via email to myself, etaylor@foxrothschild.com, along with the passcode, and a CLE form will be provided for you. Again, thanks for joining us today. Now, I'd like to present our speaker, Mr. John A. Birmingham Jr., Esquire. John A. Birmingham Jr. Esquire is a licensed attorney in New Jersey who has over 17 years of experience as an in-house counsel and is currently an associate general counsel at Breckenridge Pharmaceutical, Inc., where he handles corporate law, transactional matters, business law matters, and contract law. Additionally, he provides pro bono legal services for the disadvantaged students and the elderly. Attorney Birmingham is admitted to practice in the United States Supreme Court, the Supreme Court of New Jersey, and all other state courts of New Jersey, and admitted to the District Court for the Federal District of New Jersey. Attorney Birmingham is a professor where he teaches constitutional law, government law, business law, and various health law classes, along with others for Purdue University, St. Leo University, Centenary University, and Southern New Hampshire University. Professor Birmingham received his Bachelor of Science in Justice Studies at Arizona State University, his MBA with a concentration in criminal justice at St. Leo University, and his Juris Doctorate at Catholic University in Washington, D.C. In 2013, Centenary University awarded Professor Birmingham with the Adjunct Excellence Award as voted by students in the program, and in 2021, he received Faculty Member of the Year as voted on by faculty at the Centenary University. He received Adjunct Professor of the Year for Purdue University in 2015, 2020, and 2022. He has created course curriculums for the classes Healthcare Legislation and Regulation, Legal Method and Process, Organization and Function of State Government at Purdue University, the course curriculum for Personnel Law and Ethics at St. Leo University, and the course curriculum for Business Law 1 and 2 and Employment Law for Felican University. Furthermore, John Birmingham was elected by the people of Upper Mount Bethel, Pennsylvania in November 2015, General Election Board of the Board of Supervisors, and has been a supervisor since 2016. John was reelected to the Board of Supervisors in 2022, where he will serve until 2027. John has authored 4 children's books: Our Gift from God, The Firefighters of Upper Mount Bethel, The Road Crew of Upper Mount Bethel, and Our Family Picture. He lives in Upper Mount Bethel with his wife Laura, their 8-year-old son John, also known as JC, and 4-year-old son Michael. He has published articles for the National Association of Legal Assistance Paralegals, NALA, and worked on their examination courses for paralegals. John speaks to paralegal associations throughout the United States every year. Please join me in welcoming Mr. Birmingham as our presenter today.
Thank you, Elena. Thank you so
You're
much. And honored to be here today. So thank you to the Dallas Area Paralegal Association for having me today. I'm honored to be here. So feel free to ask questions as we go through this today's presentation, how the Constitution gave women a right to choose and what happened 49 years later. No need to give any more background about myself. There's a picture of my family. You can all see that. That's Michael on the left, my wife Laura, JC, and me. So that's our family. So what we're going to talk about today is we'll start with discussing the Roe v. Wade case and the Dobbs v. Jackson case, which basically overturned Roe v. Wade. As we go through that, we'll talk about the right to privacy, where the right to privacy came from in the Constitution, how that eventually led to the Roe v. Wade decision. We'll also talk about some ethics. We'll talk about constitutional reasoning behind the Roe v. Wade decision, how Roe v. Wade also influenced other Supreme Court rulings. And then we'll get to the Dobbs v. Jackson Women's Health Organization case and why the Supreme Court overturned Roe v. Wade. And time permitting, because I'll try and leave some question and answers at the end, but feel free to jump in during the presentation if you have questions. But I'll also try and get to where the future is headed and what might happen about a woman's right to choose. My disclaimer here is I am not going to be advocating either side of the abortion issue. I'm taking a neutral approach, and I leave it all to you to formulate your opinion on Roe v. Wade, Dobbs v. Jackson, the future of abortion in America, a woman's right to choose, but I am taking a neutral approach. Okay, so before the Dobbs v. Jackson case came out by the Supreme Court, the opinion was basically leaked, right? And you might all remember that in the news. But there was a leak at the Supreme Court that said the Supreme Court was on the verge of overturning the Roe v. Wade ruling, and many questions started coming up how we got to this point in legal history. As you know, there's 9 Supreme Court justices on the Supreme Court, and there were at least 5 or 6 of those justices that were ready and prepared to overrule the Roe v. Wade case. I will also keep an area on the chat as well. So if you want to put questions in the chat area, feel free to do that. So Roe v. Wade, 1973, legalized the right to have an abortion up until the point in which a fetus can survive outside the womb, which is roughly 24 weeks. Under this ruling, states have been able to regulate, but they could not fully ban abortion before the point of viability. And that's how it stood for 49 years. Here's a picture of Norma McCorvey, who is Jane Roe in Roe v. Wade. This is her with Gloria Allred, who is a high-profile attorney and seems to represent high-profile individuals. So what did this leaked Supreme Court, SCOTUS is Supreme Court of the United States, what did the opinion say? Opinion said there's no constitutional right to abortion and that Roe v. Wade was wrong from the start. When Roe v. Wade was ruled upon back in 73, it talked about a right to privacy. There is no right to privacy specifically listed in the Constitution. Nowhere in the Constitution does it say individuals or women specifically will have a right to privacy, or individuals have a right to privacy. There's nothing specifically in the Bill of Rights or the Constitution that guarantees that. Supreme Court has inferred through the Fourth Amendment, through the First Amendment, through the Fifth Amendment, through the Ninth Amendment, that there's a fundamental right to privacy. And that's where the Roe v. Wade decision came from. Also, through the 14th Amendment due process clause. So, back in 73, the Supreme Court inferred that a woman must have a fundamental right to privacy to her body, and that the government can't intrude into a woman's body to see if she's pregnant or not. However, the Supreme Court comes back today and says there's no constitutional right to abortion, and Roe v. Wade is wrong. By the Supreme Court coming out with this opinion, it basically wanted to give states the power whether to ban or heavily regulate abortions. So this draft opinion comes out. It's not a Supreme Court ruling yet, but the opinion rejects Roe v. Wade and subsequently Planned Parenthood v. Casey. And Planned Parenthood v. Casey in 1992 reaffirmed the Roe ruling, saying it was case law precedent. We're not gonna overturn Roe v. Wade. It's good law. It's case law precedent. It sticks. But now the Supreme Court comes back and today and says, well, Roe v. Wade got it wrong from the start. There's nothing in the Constitution that guarantees women a right to abortion. And I see, oh, okay, Karen. So the amendment numbers that infer a right to privacy are the First Amendment, the Fourth Amendment, the Fifth Amendment, and the Ninth Amendment. You could even put the Third Amendment down as well, because even though the Third Amendment says government can't force us to quarter soldiers, the Third Amendment isn't really used anymore, but that infers that you have a right to privacy in your home. Kelly. Yeah, Kelly, I will get to that. Good question. No problem, Karen. So right here, Supreme Court says Roe and Casey must be overruled. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. And that's an interesting statement, that we're going to give it to the elected representatives rather than have the Supreme Court tell you whether a woman has a right to choose or not. Put it in the hands of the elected representatives. So it was called, this leaked document's called the first draft of the opinion of the court, dated February 2022, written by Justice Alito and a 6-3 conservative majority that basically decided that Roe v. Wade needed to be overturned. It was based off an oral argument back in December regarding Mississippi's bid to revive its ban on abortion after 15 weeks. So that's how the case gets up to the Supreme Court. Mississippi puts a state law in place that bans abortion after 15 weeks. Remember, Roe v. Wade basically said viability is up to 24 weeks. Mississippi lowers it and says at 15 weeks, after 15 weeks, there's a ban on abortion. Okay. Um, Alito, like I said, was assigned to write the majority opinion, and it was going to rule on it before its term ended in 2022. Why this leaked document was so critical and why it was such a breach of trust of the Supreme Court is that votes and opinions in a Supreme Court case aren't final until a decision is formally announced. And the big question was, um, you get a couple of justices who decide to change their mind as they're going through their analysis, their review, their research. Supreme Court justices can change their mind, especially if you have a justice who's a swing voter, which Chief Justice John Roberts has been known to do. He's known to rule with the majority, the conservative majority, and he's been known to rule with the liberal justices who are currently in the minority. Here are the protests against all the conservative justices, as you can see right there. The concern of Roe v. Wade being overturned is that there were 26 states that were already certain or likely to restrict abortion if Roe v. Wade was overturned. And out of those 26 states, 22 had a near total abortion restriction that would kick in as soon as Roe v. Wade was overturned. So the states that you can see in front on the PowerPoint, like Alabama, Arizona, going all the way to Wyoming, put laws in place that said if Roe v. Wade is ever overturned or is no longer good case law, this law automatically kicks in and abortion is now banned within that state. So, again, staying neutral here, women in those states it could be argued that they were put at an undue hardship if all of a sudden one lady lives in Alabama restricts abortion, and this lady no longer can have an abortion, and she's got to go to a neighboring state or she's got to go up north. So that was the concern of why this Supreme Court opinion was so dangerous to be leaked, because one, it puts the justices' lives at stake, and two, knowing how the justices are going to rule, other states can begin working on laws right away. So there was a big concern that this was going to become a disaster for the Supreme Court, and luckily none of the justices were harmed, but there were protests, there were threats, there were visits to the Supreme Court justices' house or homes, and that became part of the danger of whoever did this. And they never revealed who did this or when it was done, how it was done. So I don't know where it stands, but I know Chief Justice John Roberts did call for an investigation on this. Texas had a law banning abortion after 6 weeks, and it was allowed to go into effect by the Supreme Court because Texas has this unusual civil enforcement structure. So Texas was allowed to put the law in place that banned abortion after 6 weeks. 16 states, which include New York and DC, protect the right for a woman to obtain an abortion. And Governor Hochul of New York has been very vocal about this and the overturning of Roe v. Wade, welcoming women into the state of New York if they want to obtain an abortion. Justice Alito, along with Clarence Thomas, Gorsuch, Kavanaugh, and Barrett, voted to overturn Roe v. Wade. where the liberal justices at the time, Breyer, Sotomayor, and Kagan, were in the minority and dissented. And it wasn't clear at the time how John Roberts would vote. And again, that's another reason of why this opinion getting leaked was so dangerous. Let me see it. Question from Laura. Can you comment on the state attorney generals, including Texas, that they can subpoena medical records from medical providers of women seeking health care, even when traveling out of state? Um, yeah, I think you're getting right into privacy rights again, and I think it's a big issue. You're getting into HIPAA as well, and so I think it's and it can be considered an invasion of the right to privacy of these individuals. Um, they want information from the medical providers to make sure there's no illegal activity or women aren't um, obtaining an abortion in a specific state. It's basically done to make sure that medical providers are sticking by state law. And but I think it's a fine balance with the right to privacy, and even traveling out of state. Again, I would say it's a privacy issue. I think it's a privacy violation, and yeah, it's an interesting question, but that's basically my thoughts. Feel free to share your thoughts on it, but I think you're getting into privacy violations. Marianne, no, I never found out who leaked the opinion. I'm going to jump around because my presentation has a lot of slides. I'll send you the slides. You can do a lot more reading behind this, some of the with the leaked opinion and everything. Uh, the Roe v. Wade law clerk, uh, Ziegler, who helped write the Roe v. Wade opinion, because as you know, law clerks tend to write the opinions for Supreme Court justices. So Ziegler had his hand in writing the opinion of Roe v. Wade. Um, Basically, Justice Blackmun and his use of substantive due process was used to give a woman the right to privacy, which guaranteed a woman's right to abortion. Basically, the 14th Amendment. And that's where it came from. It came from the Fourth Amendment and the 14th Amendment. Oh, that's great. Thanks, Laura. So the use of substantive due process in Roe v. Wade, the clerk said, was not advisable. He would have decided it on differently on a different basis. And let me find one of the comments. I know there was a comment from Kelly. Justice Ginsburg, who was always uh, felt that Roe v. Wade was decided on the wrong grounds and should have been decided under the Equal Protection Clause versus a right to privacy, is an interesting argument. And basically, using, in a sense, equal protection protects against discrimination, right? So Ginsburg basically felt that Roe v. Wade should have been decided incrementally, basically where a woman is along in the terms of being pregnant. In terms of equal protection, is that women should all be treated similarly, and if one woman can obtain an abortion for health reasons, but another woman can't, are you discriminating against that woman? And that's somewhat of what the argument goes. But I liked Ginsburg's observation. I think I do think there is a right to privacy in the Constitution inferred, but when you have Supreme Court justices saying, well, here's a right to privacy here, there's a right to privacy there, there's a right to privacy there, you're basically getting Supreme Court justices legislating from the bench. They're telling you what a right to privacy is and where it is within the Constitution. Um, yeah, no problem. Okay. And I'll talk a little bit more about that later as well. Um, let me jump ahead here. So, substantive due process. This is exactly where Roe v. Wade came out. In the 14th, we have two due process clauses within our amendments to the Constitution. We have a due process clause in the Fifth Amendment, and we have a due process clause in the 14th Amendment. In the Fifth Amendment, the due process clause really deals with procedural due process, meaning the government has to follow the same procedures along the way within a judicial setting. In the 14th Amendment, there's also procedural due process, meaning the state governments have to follow it, but there's also substantive due process. And substantive due process protects certain fundamental rights, even if they are not explicitly mentioned through the due process clause of the Fifth and 14th Amendment. So it's basically saying, even if this right, like the right to privacy, is not specifically mentioned in the Constitution, the justices can infer there's a right to privacy. So fundamental rights that the Supreme Court has said is found in the Constitution include the right to privacy, to sexuality, to family planning decisions, to contraceptions, to decisions about marriage, education of children, and until June of 2022, also included abortion. Now, abortion is no longer considered a fundamental right within our Constitution. So the question is, in 1973, Supreme Court inferred that there was a right to an abortion under substantive due process and a woman's right to privacy. However, now in 2022, Supreme Court says no, abortion should have never been included as a fundamental right under substantive due process. And my question is, what changed? What changed? Why did the Supreme Court in 73 say a woman has a right to choose, but now in 2022 it goes back to the states? And I'm not saying Supreme Court got it right or wrong. I'm just saying what changed. And maybe you can argue medical technology changed. We've come a long way since 1973, and maybe we can understand or a fetus can be viable sooner, right? With certain medical health care. I don't know, but that's basically something to think about. What changed from 1973 to 2022? There's Mississippi's Gestational Age Act is the law that went into place that was challenged in the Supreme Court. This act provided in a medical emergency or in a case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being. If that unborn human being is determined to be greater than 15 weeks. So the respondents here, Jackson Women's Health Organization, which is an abortion clinic, one of the doctors challenged the act in federal court, saying that it violated case law precedent that establishes a constitutional right to abortion, as specifically stated in Roe v. Wade and affirmed in Planned Parenthood v. Casey. So Roe v. Wade in 73 defined viability as the ability to live outside the womb, which usually happens between 24 and 28 weeks after conception. What this Mississippi law did, that was put in place, required physicians to have admitting and staff privileges at local hospitals and be board certified in obstetrics and gynecology. District court held that preliminary injunction preventing state from initiating criminal or civil penalties was warranted. So the JWHO, Jackson Women's Health Organization, filed suit challenging enforcement of this state law, saying that it was unconstitutional of a state law requiring physicians to obtain admitting privileges at a local hospital. The state said basically what Mississippi said it was going to revoke the JWHO license, and it had a hearing set for April 18th, 2013. The plaintiff exhausted all available avenues in which to comply with the House bill, and the court in this case concluded that the plaintiffs were entitled to preliminary injunctive relief, and the state will not be allowed enforcing the admitting privileges portion of the act only. So it goes up to the federal circuit, goes up to the Fifth Circuit, and the issue in this appeal is whether Mississippi can impose a regulation that's effectively going to close its only abortion clinic. There's only one abortion clinic at the time in the state of Mississippi. State says, hey, you can always go to Tennessee, Louisiana, or Alabama without any undue burden in order to obtain an abortion if a woman wants to do that. So you can see how the case is making its way through the federal system here. So then it gets up in 2019 after appeal. You know, this case has been going on for years. There's been appeals. Then it was looked at whether the act was an unconstitutional ban on pre-viability abortions as pre-established in Roe v. Wade. Court of Appeals says states can regulate abortion procedures prior to viability as long as they do not impose an undue burden on the woman's right, but they cannot specifically ban abortions. The law at issue is a ban. Is it? I mean, that's the question. It could close the only abortion clinic in Mississippi, but does that make it a ban on abortions? Is there a way that an abortion clinic could open up in Mississippi and follow this Mississippi law that was put in place? And the Court of Appeals basically said the law at issue is a ban. And we affirm the district court's invalidation of the law, its discovery rulings, and award of permanent injunctive relief. It's sent up to the Supreme Court, and the Supreme Court says, yes, we'll hear it. Here's what the question, oops, sorry. Here's what the Supreme Court was dealing with. The critical question was whether the Constitution properly understood, meaning the Constitution as it's properly understood, confers a right to obtain an abortion. Supreme Court is going through its opinion and says the Constitution makes no express references to abortion. And it's really dealing with what is inferred in the Constitution, right? Because gay marriage is not specifically listed in the Constitution, but under substantive due process, homosexuals have a fundamental right to marry. Here, it's saying the Constitution makes no express references to abortion. Court precedent holds state regulation of abortion is not a sex-based classification and so is not subject to heightened scrutiny. So there, right there, they're shutting down Ginsburg's argument to decide it under the Equal Protection Clause. It's saying it's not a sex-based classification. Ginsburg said you should have done it in increments, meaning where the woman is along within her pregnancy. Federal Constitution does not provide a right to abortion, and authority to regulate abortion must be returned to the people and their elected representatives. Why do you think the Supreme Court decided to give the say on abortion back to its elected representatives? And I'll pause for a minute if anybody wants to chime in. Is this where the right to abortion should be decided with the elected representatives? D, because they did the math. I'd love to have you clarify a little bit more on that. Kathy, conservative politics. Yeah, I think you can make an argument that it was a political issue. I definitely think the argument can be made.
Excuse me, sir. I was going to say, Jamel Bowie in the New York Times wrote a really interesting article last week about the parallel between the differences in slavery laws among the states and the difference in right to abortion laws in different states, and saying they both basically dealt with bodily autonomy, and that Abraham Lincoln wrote before the Emancipation Proclamation Act that it's not feasible and not practical to have certain states allow slavery and others not. And personally, I tend to agree with that, because I had a discussion with a young man from Harvard who had graduated from Harvard, and a young woman. One was pro, one was against. And I said, well, if one holds the position that abortion is murder, then why is the Supreme Court okay with allowing certain states to allow murder? And he didn't have an answer. But basically, I think it does kind of come down to bodily autonomy. And I think it's, if we are considering the life of a fetus, then why would it be legal to murder in one state and not another? So I hope that made sense.
Yeah, no, it's a good point, Karen. It really comes down to whether it should be an individual state decision or whether the federal government needs to, in a sense, make a blanket policy over all 50 states. And they did it with homosexual marriage, right? The Supreme Court came in and said homosexuals have a fundamental right to marriage. But with abortion, we're going to give it to the elected representatives. And again, I'm not saying whether I'm for the Supreme Court's decision or against it. I'm just trying to argue, in a sense, both sides. Because you could say, you could argue, well, give it to the elected representatives because you can't have the Supreme Court legislating from the bench. And that's what they did in Roe v. Wade. But anytime the Supreme Court comes down with a ruling, isn't that, in a sense, legislating from the bench? Because the Supreme Court is really, the Supreme Court's role is to interpret the Constitution. The legislative branch is the branch that writes the laws. And I think the Supreme Court here said we can't keep inferring certain things within the Constitution. We're basically leaving it to the states and the elected representatives to go forward and do what the people of that state want. Don't let 9 Supreme Court justices tell you whether a woman should have the right to choose or not. But like your point, Karen, that you made, which is a good argument, is that it is about autonomy and whether the government can go into, in a sense, look inside a woman's body to find out how long she is in terms of her pregnancy and whether the fetus is viable or not.
Just one last quick question. Does not the federal constitution supersede the state constitutions?
I'm sorry, say it again.
Doesn't the federal constitution supersede the state constitutions?
Yeah, federal law trumps state law. Yeah, that's right. I'm just looking at other comments, whether there
That's
should
all I
be,
had. Thank you.
yeah, sure. Whether there should be a federal ban on abortion. Yeah, I'll leave that to the politicians. Let me jump ahead. So here's basically what the Supreme Court was looking at. And the Supreme Court's decision in the Dobbs v. Jackson case, it says the Constitution does not confer a right to abortion. And this is just what I was going on. That the Constitution was not properly understood in Roe v. Wade, and also overruled Planned Parenthood v. Casey. So a proper application of stare decisis, which is case law precedent, requires an assessment of the strength of the grounds on which Roe was based. So the court turns to the question that the Casey plurality did not consider. Here's furthermore in the Supreme Court's ruling, basically talking about substantive rights that are guaranteed by the first 8 amendments to the Constitution, and those rights deemed fundamental that are not mentioned anywhere in the Constitution. So what it decided is it's looking, if there's a right to free speech as stated in the First Amendment, the Supreme Court is going to look at whether that right is deeply rooted in our history and tradition and whether it's essential to the nation's scheme of ordered liberty. Free speech, I mean, that's one of the reasons that we signed the Declaration of Independence, because we weren't being allowed to exercise our right to free speech and speak out against the government, or a right to protest, or a right to association. So you could see free speech and the First Amendment rights are deeply rooted in our history and tradition. Supreme Court is coming back and saying that's how we're able to infer something is guaranteed under substantive due process. And you can even make the argument that marriage is as well deeply rooted, but it's saying abortion is not. Abortion was not deeply rooted in our history and tradition, and therefore it's not essential to the nation's scheme of ordered liberty. It goes on, the court says that liberty provides little guidance. And the only way Roe v. Wade could be upheld in this Dobbs v. Jackson case is basically whether it's a liberty interest protected by the due process clause. Let me just move this out of the way. Give me 1 second. Okay, so court goes on to say that Roe ignored or misstated history, and Casey should have never reaffirmed Roe v. Wade. Roe and Casey both said abortion right is an integral part of a broader entrenched right, maybe the right to privacy, right? And Casey described it as a way to make intimate and personal choices that are central to personal dignity and autonomy, like Karen, like you were saying. However, the court says Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. And the Supreme Court here is struggling with, when does a fetus become a potential life? Is it after 15 weeks, like Mississippi says? Is it after 24 to 28 weeks, like Roe v. Wade says? Or is it at the moment of conception, like maybe Alabama says? Why is the Supreme Court, in a sense, determining when a potential life begins? Supreme Court should not, and this is their arguments, Supreme Court should not be deciding when potential life begins. That's almost a question of science, and that's what they're arguing here. They go on to say that the historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. And this last point right here, attempts to justify abortion through appeals to a broader right of autonomy and to define one's concept of existence is too much for the Supreme Court to handle. At a high level of generality, Supreme Court then could license fundamental rights to illicit drug use, prostitution, and the like. So the Supreme Court in the Dobbs case is saying, if we're going to make a decision on when the potential life begins, or a woman's bodily autonomy, it's going to open a whole slippery slope up that the Supreme Court can decide other certain generalities, as they call it, and you're putting too much in the hands of the Supreme Court. So here's some things. Let me just check where we're at. Oh, I only got 10 minutes. Wow, I'm running out of time. Hey, if Dallas wants me to have me back for a part 2 on this, I'm happy to do it, because I'm just starting to dig into it. But let me, and I'm going to open it up for questions too, but let me just kind of leave it off on this. When does the Supreme Court overrule case law precedent? Because basically what it did is it overruled case law precedent. It struck down Roe v. Wade. So it looks at the nature of the court's error. Supreme Court did that in Plessy v. Ferguson, which was overruled by Brown v. Board of Education. The quality of the reasoning, and we'll get you can read the slides, and if you want to follow up presentation, I can always do it. But this is where the Supreme Court is going to look at when they want to overturn a case. They want to know if the court made an error, as it did in Plessy v. Ferguson, the quality of the reasoning, the workability, whether the precedent being overruled is whether that rule imposes is workable, the effect on other areas of law, and reliance interests. And I kind of give some examples here, but that's when the court is going to overrule one of its case law precedents. But what I really want to leave you with today is that this is all about judicial activism. That's exactly what it is. That's what Roe v. Wade was about, and that's what the Dobbs v. Jackson case is all about. Judicial activism, under Black's Law Dictionary, is defined as a philosophy of judicial decision-making where judges allow their personal views about public policy, among other factors, to guide their decisions. Roe v. Wade inferred a right to privacy under the 4th and 14th Amendment. Dobbs v. Jackson, you could argue, is not judicial activism because it's giving abortion decisions back to the states, or you could argue it is judicial activism because the Supreme Court went right back in and said, no, there's no right to privacy. There's no fundamental right to abortion. Is that judicial activism, or is that judicial restraint? And that's something I can talk about at a future seminar. But that's really what you're getting to, is what is the Supreme Court's role in a decision like this, in a decision on a woman's right to choose, or on fetus viability? What should be considered a fundamental right within the Constitution? Marriage is, sex is, free speech is, the right to privacy is, but a woman's bodily autonomy, we're going to let the states decide on that, because that's too much of a scientific question, not a legal constitutional question. And that's where I think the Supreme Court was going, from reading their opinion, that they're not doctors. They didn't want to decide it. Give it to the states and let the states decide how they're going to rule. Let me just give a couple quick questions right here. Before I get to questions, let me just go over this. Congress, now that Roe v. Wade is no longer good law, Dobbs v. Jackson is, what can Congress do? Congress can override the Supreme Court decision by passing new legislation. If a Supreme Court decision is made on constitutional grounds, Congress can amend the Constitution to influence Supreme Court's decision or strike it down. So I know President Biden has talked about trying to do legislation. It's difficult, but it can be done if the Biden administration or a future administration ever wanted to try and do something about this Dobbs v. Jackson case. Congress can amend the Constitution and can always specifically say a woman has a right to an abortion. There can be new laws made, and that can affect federal law or new court rulings. Congress can also decrease or increase the number of justices. Someone had the comment, do the math. If you get a lot more liberal justices and conservative justices, maybe you can strike down or overturn the Dobbs v. Jackson case. Congress has the power to approve and impeach justices for incompetence or misconduct. However, I don't think any of the Supreme Court justices were incompetent or committed misconduct in the ruling on the Dobbs v. Jackson case. These are some other cases I can get to if you ever want to have a part two. There's me having an aha moment. I don't know what my aha moment was, but there it is. But I'll open it up for questions, and I put my phone number, my email address. If you all ever have a question or you want to email me a question, you can call me, you can email me, you can text me. If you want to stay connected in any way, I'm on LinkedIn and Facebook, and I use both for networking purposes. Feel free, and I also put goofy pictures of my kids up there. So feel free to stay in touch. I was honored to speak here today for the Dallas Area Paralegal Association. Thank you for having me. I think I'm back here in November. For I think the Fifth and 14th Amendment, and I can always talk more about the Roe v. Wade during the Fifth and 14th Amendment. Okay, let me see if there are any questions in the chat area. But thank you very much, guys.
Thank you so much, Mr. Birmingham. We appreciate that presentation. And yes, we would love to have you come back for a part two.
Okay,
so
fantastic.
We can get that scheduled.
Great. It looks like there's a question.
I'm just going to jump in and ask it. Is there somewhere we can follow you, or is LinkedIn the best place as far as looking for other areas that you do talks on constitutional issues?
LinkedIn and Facebook. I promote on both. So
okay, perfect.
Yeah.
Thank you.
Okay, yeah, go ahead and friend request me.
Awesome. Thanks.
Yep.
Okay. All right, and our Dapper President Melody Johnson said to tell you hi, and she apologizes for missing today's presentation.
Oh, no problem. Did I miss any questions in the chat area?
See, it says there's been talk of going after contraception. Do you believe this is realistic? That's from Kelly Blackburn.
I don't think they're going after contraception. That would be, then you're getting into the right to privacy in a bedroom. And I don't think the court has the power to go that far. I mean, they've tried it once before, and the court struck it down. So I don't. I think abortion was more. Listening and reading the Dobbs opinion was more of a medical question. I think conception's getting at to more of a privacy. Yeah, and Clarence Thomas saying that we may go after gay marriage and contraception. I mean, what he's saying is that we're gonna not let the Supreme Court infer things within substantive due process. And Justice Scalia was a big opponent of substantive due process. He called it judicial stew. And he said, it's basically just having justices decide what is due process or what do people have a fundamental right to. Let me see. There doesn't seem to be anything. Yeah, I mean, that's a good point, Beverly. You don't have to be a lawyer to be on the Supreme Court. Could a doctor be on the Supreme Court? Sure.
Yeah.
Would he have, or would she have tough time reading legal opinions? Just the more you do it, the better you get at it. So it's just about practice, right? But that's a great point, Beverly.
I have a question.
Uh-huh.
I wrote in the chat, so rape, incest, or death have no bearing on any of these cases? I mean, is there anything that can be done? You know, like you're raped, you have to have the baby. If it's going to cause your death, you have to have the baby. Well, I don't.
It's really up to the states at that point. You know, a state could make an exception for if the woman's life is in danger or if the woman was raped. Basically, a woman doesn't have a constitutional right to an abortion, but a state can say, you know, look at New York. New York provides for abortions for whatever reason. A state, it's really saying you're going to have different state laws now where abortion may be banned in Alabama, allowed in New York, or only allowed if the woman's life is in danger. Good question, though.
Thank you.
All right. Again,
right,
thank you
everyone.
all so much. Yeah, go ahead.
Thanks for attending. Nice meeting you all. And
Hey guys, I think Rihanna has her hand up. Rihanna, can you address your question, dear? Yeah,
Oh, I'm sorry. I just forgot to put it down. Yeah, I
Oh,
already
okay.
asked.
Making sure we got you taken care of. Okay, cool.
Thank you. Good looking out.
have a great day, everyone. Thanks for having me.
Yes, thank you all so much for attending. Thank you. And yes, we will get Mr. Birmingham back for part 2.
Thank you so much. Bye.
Thank you.
Bye. Thank you.